student, this is another important video on recent judgment of the Supreme Court of India, as we have discussed earlier about, that is about electoral bond scheme. So now we are discussing about another important legal issue, and this legal issue is related to the criminal law. So now I am going to discuss about another important judgment of the Supreme Court, and the name of this judgment is about, and that is Somnath versus State of Maharashtra. So this is going to be another important judgment of the Supreme Court related to the criminal laws actually. Somnath versus State of Maharashtra. Somnath versus State of Maharashtra. इस judgment में Supreme Court ने एक very, you can say, very strong approach adopt किया against the police authorities. As we remember always, whenever we talk about the criminal law and when we talk about that is the procedure of arrest of the police officer, we can recall that time to time Supreme Court of India has given so many guidelines that how one should be arrested. We can recall about Arnesh Kumar versus State of Bihar. We can recall about D.K. Basu versus State of Bengal. There are various judgments in which time to time Supreme Court has actually protected the right of the arrested person. But now the Supreme Court has expressed its displeasure. Supreme Court has referred that despite having an exact statutory provision, despite having the plethora of judgments regarding the procedure of arrest, the police authorities are not taking into consideration. The police authorities are violating the rights of the arrested person. They are using very tyrannical and tough approach during the arrest procedure. So in this judgment, Supreme Court has reminded these police authorities that if they are not going to adopt the exact policy during the arrest procedure, then they will be sanctioned to the contempt of the court also, as well as to the rigorous punishment. So now I am going to discuss about this judgment, because इस judgment में Supreme Court ने completely zero tolerance approach को adopt किया, that any time if irresponsible high-handed acts had been done by the police officer during the arrest, then they will be liable for punishable offense. So this was the actual statement which we can say that another instance when Supreme Court has warned these police authorities not to take rigorous procedure, violating the exactly procedure and constitutional mandate provided. So now just think about that what has been discussed in this judgment. That first of all, in this judgment, Supreme Court has, as I said earlier, that has expressed displeasure with the conduct of the investigating agencies and the police officer for not adhering to the statutory as well as constitutional safeguards. Supreme Court has warned कि आप arrest करते समय या during the whole period of arrest, they should follow the norms. They should follow the constitutional norms. They should follow the norms which are provided already in the Criminal Procedure Code 1973. So, Supreme Court ने बोला that during custody, the detainee should be given at least all those rights which were already provided in the statutory provision. Now, Supreme Court once again reminded these authorities that why should you not recall this judgment that was a wonderful judgment in the case that is D.K. Basu versus State of Bengal in the year of 1997. D.K. Basu versus State of Bengal 1997 is the crystal clear judgment of the Supreme Court in which Supreme Court has given the various guidelines, various rules related to the norms when the police officer is going to arrest any person. यहाँ पर we are having so many rules which were set by the Supreme Court of India at the time of 1997, which were at the later stage were incorporated into statutory provisions under the criminal law under section 41A, 41B, 41C and 41D of Criminal Procedure Code. So now what were actually given in the guidelines in the D.K. Basu? I am giving you a brief of that, but I am suggesting all the students who are watching this video, please go through the guidelines which were provided in the D.K. Basu. The guidelines, some of the guidelines were that whenever the police officer is going to arrest any person, that person should give the visible information about that the person was actually the police officer. There should be apparent look like that he is a police officer. There should be all the norms should be followed, that within 24 hours the person should be presented to the judicial officer. The person who has been detained is having the right that the information about his arrest is to be given to his near relatives or friends. Another kind of rule was again that when the person was arrested during the custody, he should be given the right to consult with his legal advisor. मीन्स आपको लीगल राइट है कि आप अपने लीगल एडवाइजर के साथ कंसल्ट कर पाओ कि वेदर यू आर हैविंग द राइट टू बी रिलीज ऑन बेल, ऑन बॉन्ड एंड अदर थिंग्स एटसेट्रा. So there were various rules were provided under these rules of judgment, and the Supreme Court has said कि जो DK बसु का judgment है इसको टाइम टू टाइम हम ऑलरेडी क्रिमिनल प्रोसीजर कोड में इंक्लूड कर चुके हैं. एज आई रिफर्ड हियर दैट इन द ईयर ऑफ 2008 सुप्रीम कोर्ट ने एक इफेक्टिव गाइडलाइंस को इनकॉर्पोरेट किया गया विच वर इन्फोर्स इन द ईयर ऑफ 2010, जहां पर सेक्शन 41A से लेकर सेक्शन 41D तक जो रूल्स थे वो यहाँ सेट किए गए. नाउ एज वी रिमेंबर दैट इन प्लेस ऑफ क्रिमिनल प्रोसीजर कोड 1973 we are having another important new legislation in the name of भारतीय नागरिक सुरक्षा संहिता 2023. इस भारतीय नागरिक सुरक्षा संहिता 2023 में भी इन सारे प्रोविजंस को इनकॉर्पोरेट किया गया है और इन प्रोविजंस को इनकॉर्पोरेट किया गया है फ्रॉम सेक्शन 36 to 39. तो बेसिकली जो कुछ DK बसु वाज स्टेट ऑफ बंगाल में अरेस्टेड पर्सन को प्रोटेक्टेड करने की राइट्स प्रोवाइड की है सुप्रीम कोर्ट ने, उनको इनकॉर्पोरेट किया गया इसमें एंड देन नाउ भारतीय नागरिक सुरक्षा संहिता में. सो व्हेन देयर आर ऑलरेडी द स्पेसिफिक प्रोविजन व्हिच वर प्लेस्ड इन योर स्टैट्यूटरी प्रोविजंस and under article 21 of the constitution of India also we can recall that whenever we talk about the right of any person including the arrested person, that person cannot be deprived of his right to life and personal liberty without the procedure established by law. Please remember student, the procedure established by law must be just, fair and reasonable. So the police authorities are bound by these constitutional norms as well as statutory provisions given under section 41A to 41D, now placed under section 36 to 39 of BNSS 2023. इसके बाद पुलिस अथॉरिटी के पास ये ड्यूटी है. Why didn't they follow it? तो सुप्रीम कोर्ट ने इस जजमेंट में ये बोला कि दैट पुलिस अथॉरिटीज whenever are going to arrest any person, they cannot, they must not disobey the statutory provisions. They should rigorously follow the rules whenever they are going to arrest the person. In case they violate these rules provided under statutory provisions or the constitutional norms, they will be subjected to the punishment which shall be rigorous in term. So this was the judgment which was very important in this regard, and as I said to you that in the year of 2024 we are back to back taking very important case laws in this regard. So ये judgment एक one of the important judgment है जिसमें कि हमारे constitutional rights के बारे में बात हुई. We can take this judgment in the constitution also, and we can also refer it in criminal law. Criminal law means to say now we are having BNSS, but for the person, for the student who are appearing for the exams in present time, they need to refer here is still CRPC 1973, right? So this is the judgment which is very important whenever you are referring about the rule related to the procedure of arresting a person. Okay, so you need to mention about this important judgment, you need to refer these provisions, and you need to understand the Supreme Court has warned these police authorities not to disobey these rules. This was all. If you want to watch any other important videos on the recent Supreme Court judgment of 2024, you need to wait, and then you need to have another important judgment in this regard. Thank you so much for watching this video.